and talk about the difference between the civil and the criminal court cases. Now, with the civil cases, when a lawsuit is filed, okay, it has to be served to the defendant or the respondent. With that being said, a citation has to be created by the district or county clerk's office, and a copy of the filed petition is with it, and it will be sent either to a process server, the sheriff, or the constable. Once they have received that and they have served it, the constable, sheriff, or the process server has to file what's called proof of service or a return of service to the court within a certain time frame. Failure to do so would be on them. Service is probably the most important step in a civil litigation, because if the other party is not aware that they have been sued, then you have a fighting chance to get whatever it is dismissed. So that's why service is important. I've heard a lot of things about, well, Krishan was served at a football game. She wasn't. Let me tell y'all something. I have served people at a restaurant, at their home, at their place of business, wherever the case may be. It does not have to be your residence. If we have tried multiple times to serve you at your residence and you're not there, I'm going to serve you where you work. If that doesn't work out, and we may have a PI and they say, well, we see this individual at this location all the time, I'm going to serve you there. But what happens is the court has to amend the citation, right, to have that particular service address. So if I see, now I'm not saying for me, but if I see you going to church on Sunday at this location, then, but I'm pretty sure we will never do that. I should say like the mall. If I see you going to the mall every morning to do your little 2-mile walk, right? I am going to have the court clerk amend the citation to put that address, and then we can go ahead and serve you there. But sometimes that's not even necessary. It's just with the process server, and the process servers usually have the same database as us, paralegals or attorneys have, and we could just look at the last known address and we say, okay, try this address. If that doesn't work and we see, okay, we have a work address, try that address. So it doesn't matter where you are, you can be served anywhere. So just be mindful of that. Now, once you are served, you have a certain amount of days from the day that you were served to file a response to that lawsuit. If you do not file in a timely manner within that time frame, the other party can go ahead and file a motion for default judgment. And that's a whole nother rabbit hole I can go down. But in the event that they do, then the case goes on. So here we have lawsuit, complaint served, and then defendant files. Now, one thing I do want to tell you guys is that mediation requires the presence of both the defendant and the plaintiff. That is not something that can be missed. Now, just because either or does not show up, that does not mean that they're going to go to jail. Mediation can happen at any time during that process. It can happen as soon as they get served a copy of the lawsuit. Okay, think about Diddy's case. As soon as Cassie filed, he settled. Why? Because they mediated before they did anything else. So mediation can happen at any time, but it does require the presence of both parties. Now, going down to the bottom, once the complaint is served and we're waiting on the defendant or the respondent to respond, we start our discovery phase. So that means I am drafting up questions that I need answered, documents that I am requesting, and I need you to answer to these admissions. I send that over. So once the complaint has been served and the defendant goes ahead and they file their answer, I can go ahead and issue out that written discovery for them to, answer these questions and produce these documents. And that is the same on the plaintiff sides. If the defendant hires a lawyer, then their attorney is going to draft written discovery for the plaintiff to answer, and so on and so forth. So that is how that works. Once they have answered the questions, provide certain documents, and answer to the admissions, then we move on to depositions. Depositions is just pretty much in front of a court reporter. Sometimes they are taped, but it has an opportunity for each counsel to depose each party, the plaintiff and the defendant. And they use all of this, including the written discovery, to build their case. After depositions, then we hire experts based off of, the type of case. We may have one, two, three experts, and it just can be for a number of things: a medical expert, a vocational expert, whatever the case may be. And then we'll have expert depositions. Like, okay, what is your expert, um, you know, acknowledgement on this matter? All right. So if we have an expert for the medical bills, can you please explain how, these medical bills and the medical uh what do I call it? Uh Treatment was necessary. Then we'll have somebody that explain why, the treatment that they has was necessary. Or if it's dealing with an expert for vocational reasons, as far as, this person was injured and now they have a loss of income, and we'll have an expert for that. So there's an expert for pretty much everything that we use. But all of that is included in the discovery phase. Now, yes, this is the phase, but please understand that there are deadlines for each of these things. So how do you establish the deadlines? That's why you have case management conferences. So on a lot of these cases where you are seeing there's a case managed conference hearing, that is not for the parties. That is for the attorneys and the judge. So when you're going through the discovery phase, that's not something that's going to take for a whole year. No, written discovery, I need this answered in 30 days. When it comes to depositions, deposition needs to be held within 90 days. How did they come to these dates? At the case management conference hearing. So when you look at a court docket and you see case management conference, that simply means that either the councils have got together and says, okay, here's a timeline of when things are due, or the judge may say, okay, this is the timeline when things are due. One thing they always will schedule is a trial. So based off of the evidence, they have to and I say evidence based off of the discovery in the beginning, they have to submit a case management statement. So they pretty much have to come up with a informal schedule that they have to present at the case management conference. And the judge would be like, okay, I see that you put 50 days for written discovery. No, let's set the deadline for 30 days and everything. So they have to have a trial date set in order to schedule a deadline for the pretrial events. So if your case is scheduled in December of next year, that means between now and 30 days before that date, there are deadlines that each party or each attorney has to go through. All right. There is a cutoff time for discovery because at the end of the day, you have trial. So you have to have things done 30 days before trial. You have to have discovery done. You have to make sure you have your experts, already deposed and everything. If you had mediation, that is literally the last hope to settle your case before it goes to trial. After mediation, if they have not came to an agreement, then they're definitely going to trial. But there is going to be a hearing prior to trial to see if they are ready for trial, because if they aren't, then they can always push out that trial date. Okay, I hope I did not confuse anybody there. So, this is the litigation process, and I'm going to show you guys as to why this is important.